So I'll read off the question here. If I sell on Amazon Marketplace using a common law trademark name, is the common law mark applicable to everywhere Amazon sells? I have successfully sold books to most states for 15 years, advertising them and selling them on Amazon using the same store name. Since I list that books on Amazon, they're available to view in all 50 states. Is this case, is it common law valid in all states? Someone's really trying to go on the cheap without registering.
Yeah, come on, guy. File the federal trademark and be done. Yeah, so I don't know the answer to this. I mean, it would depend on the jurisdiction, I suppose, right? Do you touch and concern each of these states, directly or indirectly? Is there a warehouse in that state for Amazon that's selling your books?
Right.
Does it transit through your state? I don't know what each state's common law trademark requirements are. What I can tell you is they're pretty worthless. So what you really want is a federal trademark because it trumps every state level trademark application or registration.
Yeah.
So, and this person may or may not be aware, but if you have a registered trademark with the USPTO or even a pending application at this point,
right,
you can apply for Amazon brand registry, which allows you to have A+ pages, which are those fancy web pages on Amazon. It also allows you to enforce the trademark on Amazon. So without that, you're kind of hamstrung a little bit in terms of your marketing opportunity. So I would just say, hey, like if you're going to sell on Amazon, you need a federal trademark application.
Boom.
That's kind of my,
you
don't need anything obviously, but you shouldn't be selling on Amazon unless you have a federal trademark.
Love it. And they'll actually help you enforce it. And that's basically what you're saying.
Yeah. I mean, same thing on social media. Unless you have a federal trademark registration, Twitter, Instagram, X, formerly known as Twitter, whatever, they're not going to do anything. They're not even going to look at it. They're going to kick it right back to you and say, we don't deal with common law trademark rights.
There it is. So get it done. You've been in business for 15 years. Goodness sakes, it is time.
Yeah.
Very good. Okay, wait, one more. And if anyone's out there listening, we ask you to, you're welcome to ask questions. We'll take yours as a priority here. This may be the same individual asking a different question. Do I need a USPTO trademark to protect my business name? I sell books on Amazon using a name I made up. 15 years of history with using it. If someone else tries to use the name to sell books, would I have to give it up?
Yeah. Well, I mean,
this is directed at you, dude. We assume
Of course you would, right? So I mean, the feds don't do anything without a registration. So if somebody else comes along and registers your trademark, they have the enforcement rights, right? So they can go pull the levers, whether that's social media, Amazon, federal district court. They get all the benefits of statutory registration, which they should because they did the right thing, and that is register the trademark so that this issue doesn't happen. If you rest on your laurels, if you rest on your 15 years of use of the product or the service, right, selling this product or service, you do probably have some trademark rights that you could register with the USPTO, depending on the name, of course. But there's nothing stopping anybody else from registering the trademark. It's not like the USPTO goes out and does a search at common law. So when the USPTO trademark examiner does his or her search, they're looking just for previously applied for or registered trademarks. That's what they're going to cite against your application. They don't care if there's 3 other people using the exact same name for the exact same products or services that are unregistered. That's, it's a self-help world. They just deal with their own little universe. So, register the trademark.
Yeah, this is what I always think of.
Probably a couple grand, you're done.
Yeah. Burger King versus Burger King.
Oh,
case study.
Classic.
I love this. Look at the 4 double cheeseburgers. They fit that all into one line.
Oh,
half-pound fries.
Can you look at that? 4 double cheeseburgers, half-pound fry, $11.99. You can't beat that with a stick, JD.
I want to go there.
Those were the days, man. Those were the days.
Newspaper stand out front.
Oh yeah.
Probably still smoking in there. But this is it. This is basically whatever that guy's name is on Amazon.
Yeah, go read Burger King.
You're the original Burger King. And so all you might maybe have rights to is wherever you can definitively prove you've done business.
And I think the court in this is a Supreme Court case, I believe, but Burger King v. Burger King is a huge landmark case in trademark law.
Yeah.
Basically, it stands for the proposition that if you have common law trademark rights, those rights don't go past the county in which you operate.
That's it. So this is able to operate right? In the same world as the Burger King that we know of,
Yep.
but they're limited to basically probably like 500 people.
Yeah. So, I mean, in this particular case, if I remember the fact pattern, Burger King, the little Burger King, the mom and pop Burger King.
Yep. Gene and Betty Hoots.
Yep. The Hoots. They went to market with Burger King. They have priority or senior rights in the brand in the area that they operate. Meanwhile, I believe down in Florida, if I'm not mistaken, there's a company called Burger King that's franchising, and they're growing rapidly.
Yeah.
And they're not the first to use the name, especially in that particular jurisdiction.
Right.
So, who wins? Well, the federal court basically says, well, the person who filed the trademark wins, because at the end of the day, they filed the trademark. They have, first use nationally, right? And this third party who has senior rights in this particular state that they're operating in, they basically can still operate, but they can't expand, right? They're locked into that, that county jurisdiction essentially. So.
But the person asking the question does have an intriguing argument, perhaps. Hey, I'm selling online everywhere, and I'm selling books in every state. It's just hilarious. I think it maybe they've got some argument.
I wouldn't want to make it though. I wouldn't want to roll into a court and claim common law trademark rights. I mean, I'm serious. Like courts don't want to, state level courts do not want to deal with trademarks. Federal judges do not want to deal with trademarks, right? Yeah. And so if you walk into a federal court, state level court and say, I have common law, unregistered rights in the trademark, judge is going to say, why are you here? Let's go figure this out. Go get a federal trademark, then go to federal court.